Yeah, we're ready to start.
Arvind, over to you.
Welcome to everybody. We are gathered here today both to release the PUCL issue paper, which is titled Repeal UAPA, the Dangerous Implications of the Supreme Court Judgment Denying Bail to Umar Khalid and Sharjeel Imam, as well as to have a discussion as part of the PUCL dialogue series on this particularly egregious judgment of the Supreme Court. If we read the judgment, Gulfisher Fatima versus State, we find that in the judgment, 5 of the accused are released on bail, which is Gulfisher Fatima, Shifa ul Rahman, Miran Haider, Mohammad Salim Khan, and Shadab Khan. Whereas the two who were denied bail, about Sharjeel Imam and Umar Khalid. And there are many problematic aspects of the judgment which have been discussed over a period of time, and we will look at it again in the course of this dialogue, including the question of the right to speedy trial, and does it apply as far as the UAPA accused are concerned? The question of the broadening of the ambit of terrorism to also include forms of peaceful protest, the idea of hyper-technical distinctions such as managers and foot soldiers to deny bail to both Umar and Sharjeel, and the concept of the protected witness, which has been introduced to introduce evidence which cannot otherwise, which makes a case for violence which otherwise cannot easily be made. And of course, the problematic conditions on bail, which deny individuals who are released their constitutional right to expression, association, and assembly, again in the conditions which are deeply unconstitutional. What all of this leads to, where all of this leads to, is in our understanding that the Supreme Court, in this case, is really diluting the question of constitutionally protected right of speech, association, and assembly. And in particular, we want to draw your attention to the question of the right to association. If we read the judgment, we get a sense that over and over again, there are references to Sharjeel and Umar's leadership role in WhatsApp groups, such as the Muslim students of JNU, such as the Delhi protest support group, and the presence in offline groups such as the Jamia Coordination Committee, Jamia Awareness Campaign Committee, and all of this, as far as the judgment is concerned, marks them out as suspicious. We also get a sense of the suspicion cast on both of them in terms of the work that they did. Sharjeel, the judgment makes the point that he was involved in deliberately invoked communally sensitive themes such as Babri Masjid, Kashmir, and alleged existential threats to the Muslim community, and as well as Sharjeel's involvement in the establishment of 24/7 protests at Shaheen Bagh. As far as Umar is concerned, he's alleged to have participated in a protest at Jantar Mantar and agreed to utilize social media as a platform for large-scale indoctrination and mobilization of youth for the purpose of enforcing a Chakka Jam. So what you get actually in reading this judgment is a sense of almost the idea that the Muslim students of JNU is a deeply problematic group. It's a deeply problematic group. And what you get is the group is exercising its constitutional right to association, assembly, as well as speech. And it's clear, if you read the judgment, that however hard the court tries, it cannot bend logic at the wheel of prejudice. The conspiracy that they're pointing out to is nothing other than the exercise of their constitutional right. So where this all leaves us actually is thinking of the two people who are still in jail as nothing other than prisoners of conscience. When we say prisoner of conscience, what we mean are people who are imprisoned for the peaceful expression of the political, religious, other conscientiously held beliefs of an identity, even though they may never have used advocated violence. What makes the imprisonment of Sharjeel and Umar even more telling in this particular case is that the ideas for which they're imprisoned are the ideas which are protected by the Indian Constitution. The idea that you cannot be discriminated against on grounds of the religion that you come from, the idea that all of us have the right to speech and have the right to expression and have the right to associate. From this, what are we supposed to conclude? Are we supposed to conclude that the state which imprisoned them has no more of faith in the idea of equality for all regardless of religion and is therefore imprisoning those who continue to believe in this idea of equality. However, we believe, as the PUCL, that ideas cannot be silenced. And as Father Stein eloquently put it, a caged bird can still sing. And the song of equality, which is sung by Sharjeel and Umar, continues to resonate with us. And I can do no better, actually, than to invoke the words of Umar Khalid himself in a recent book by Anand Teltumde, With Human Rights in India, in which he's written a blurb in which he says, I'll read out what he says, what Umar Khalid has to say. He says, when dissent is completely criminalized and all the pillars of democracy begin to crack, as they have in India over the past decade, fear seeps into everyday life. In such times, the silence around the suffering of the oppressed grows deeper. As the long shadow of fascism falls across the nation, it is those already pushed to the edges, the minorities, the marginalized, the unheard, who bear the heaviest weight. This book does not turn away from them. With compassion and clarity, it traces the quiet, often unseen toll of a democracy in retreat. Its strength lies not only in its critique of power, but in its deep attention to all those made vulnerable by its abuse. In remembering what others forget becomes an act of resistance itself. Keeping in mind Umar's call, we see this webinar as really an act of solidarity to all those who continue to be unjustly imprisoned under the UAPA, to all the Indian prisoners of conscience who are in jail for expressing their deeply held beliefs. We really hope that through this dialogue, to continue a conversation about the future of democracy in India, through a close examination of the very same judgment which is today keeping both Sharjeel and Umar in continuing imprisonment. We will end by releasing the PUCL position paper, again titled Repeal UAPA, the Dangerous Implications of the Supreme Court Judgment Denying Bail to Umar Khalid and Sharjeel Imam, with our colleagues reading out the list of demands. For us, this program is an act of solidarity. Solidarity lets you know that you're not alone. Out of a coming together, out of exercising the constitutional right of association, we believe new ideas will come. In Umar's striking words, solidarity lies in remembering what others forget. So remembering becomes an act of resistance itself. Without further ado, we can begin the proceedings with our panel discussion. I'll invite first Nadeem Khan, who's the General Secretary of the APCR, to share his presentation which he has, which puts us all on the same page with respect to the status, what happened in the Delhi anti-CAA protests, why were people arrested, what were the reasons behind their arrest, what is the stage at which the various cases are. So we all get a sense of where we are as far as the entire battle, entire struggle really today is concerned. Nadeem is, as I said, General Secretary of the APCR, and APCR is a non-profit organization which consists of lawyers, activists, and grassroots paralegal volunteers who are working to achieve an egalitarian, just society, but bridging the gap between law and society. Nadeem, over to you now.
Nadeem, we can't hear you. Are you speaking?
Sorry. Thank you, Arvind, and thank you, PUCL team, for organizing this meeting, and a meeting where the got the bail, and but the condition of the bail is like they are living still in a jail in at their places. So the story have begun at the time of 2019 and 2020, 2019 CA anti-CA protest, and after that 2020 Delhi riot have been happen. So basically, I have a long sheet, so I'll cut short my points and just introduce the people, those who are still in jail and those who have got the bail. And Khalid Safi, the person who was or one of the organizer of the second protest site just after initiated at the main Shaheen Bagh. It was a Khureji's protest site, and a Khalid Safi have been arrested on 26th of Feb, just after the next day of Delhi riot, and he was arrested when Delhi police um, when they are at the protest site and they just want to dismantle the all protest site. So Khalid have been arrested. The first arrest of these 18 people, Khalid was the first arrest on 26 February 2020, and FIR 44 and then FIR 59. So these are the section. Hope you people are watching these sections. It's a long page. That's why I'm not telling 307, 124, 153, 113P UAP and 17 and section 18 UAPA. Khalid Saifis have two more charges against Saifi. There's a one is a FIR 1012020 that is accusing him of writing, assaulting police officer and armed robbery. So in this case, Umar Khalid is also one of his co-accused in FIR 101, and then that FIR is saying, and that FIR is saying is armed at the Chandbagh area. In Chandbagh area, Khalid is have been arrested. Even the co-accused Umar Khalid was not evenly day. The FIR have been registered and saying it was a writing, assaulting a police officer and armed robbery. Armed robbery, the charges against they want to take some rifles of the police persons. So Khalid have got the bail in FIR 101 and another FIR of Jagatpuri and is still in a jail. Um, First, he arrested for the case of Jagatpuri protest site. Then, after that, on 28th of March, 24th of March, he arrested in this FIR 59, the conspiracy one. The next arrest on the same date, 26 Feb, Ishrat Jahan. Ishrat Jahan is also one of the co-organizer of Jagatpuri protest site, and Ishrat Jahan have a FIR 44 against the Jagatpuri protest sites FIR, and uh, the same day when Ishrat Jahan have got the bail from Delhi lower court in this Jagatpuri case, the same day she have been rearrested from for this FIR 59 by Delhi Police Special Cell, and in mid-June 2020, Ishrat Jahan was granted interim bail to marry her fiancé. She returned to prison on 19 June 22, 2020, and Ishrat Jahan got the bail on 16 March 2022. Again, there is a three cases against the Ishrat Jahan, and then Salim Malik. Salim Malik arrested on 11 March 2020. Initially, FIR 60, that is the Dayal police station. In the Salim Malik, the person, there is a arrested in FIR 59 for the larger conspiracy, but there is some other case as the executor also. So Salim Malik is like Umar Khalid, only the charges. These are the FIR, but on the in 101 FIR, Umar Khalid is also there. But Umar Khalid is mainly police is saying he is one of the conspirator. But in this case of Salim Malik, there is some another FIR, and police is claiming he is a conspirator as well. He is the executor also in this FIR 59. And if I'm telling you the ground story, Salim Malik have a biryani shop. Just the real picture behind the scene. The Salim Malik is having a biryani shop next to the Chandbagh protest site. At the time of anti-CA protest, he was preparing the biryani and distributing the biryani to the protesters. That was the main reason. Still, in jail, police people are calling him Biryani Baba, and the jail inmates is also calling him Biryani Baba. And the major crime is that he is offering biryani, is offering food to the protester. That's the main story. So arrested 11 March FIR 6060 June 25 he was arrested re-arrested again UAP on 59 uh, 22 to 25 multiple bail denial by trial court Delhi High Court, and they are saying they have a CCTV and CDR evidence. So the CDR evidence and CCTV evidence is like that the person is having the shop in the same area where the violence have been happened. So these are the claims police is saying that they have the CCTV footage of Salim, advocate Archit Krishna, and as well as Jawahar Raja. So another person is a
And
Salim
he was
Khan. There is a two.
granted bail. He was
Yes,
granted bail
yes.
in this
So
group of five.
the next one is Salim Khan. Salim Khan is arrested on 13 March 2020 against the major reason is a CA protest, and the nature of charges is the many other FIR apart from the 59. Then in case in 59 they have a sections of 302, 147, 307, 124, and as well as they are saying funding and the conspiracy. In February to March 2002, named in 3 post-right FIR questioning multiple time before arrest on March 13. He is the person who around 3 times police got his police remand. In 2021, bail in non-2 UAPA FIR, detained on UAPA charges, spending over 18 month bail appeal. So there is some last line is some confusion in between Salim Malik and Salim Khan. Actually, Salim Malik is still in a jail, and Salim Khan have got the bail in from last 5%. Those who have got the bail. And the major reason of the arrest, as we people are assuming, Salim Khan is having the office near Chandbagh protest site. So most of the meetings at the time of protest, so if and he's having a big office in nearby Chandbagh protest site. So most of the time women used his office washroom and meeting site, and sometime they are using his office as a storage also. So the major reason of the arrest is that meeting at his place, the so-called conspiracy meeting, which they are claiming it have been happen on 22nd or 23 night. So the same meeting, the venue of the meeting was Salim Khan's office. So Salim Khan have got the bail in last from the Supreme Court. The next one is Miran Haider. Miran Haider protest religious freedom condition, religious identity, the same CA cases, criminal case and arrest on April 1st in this UAPA. Uh, in case of Miran don't have Miran have only one case, and only one case is the UAPA. There is some charges against the funding, promoting the enmity, and 153 and section 13 of UAPA, and as well as section 18 of conspiracy. In January 26, Miran Haider released on a bail. Faraz Makbul was a lawyer since initial start at in a trial also, as well as in a high court. Siddharth Agrawal represented him in Supreme Court. Then the Shadab arrested on 6th of April 2020. Shadab was one of the co-organizer of Chandbagh protest site. Shadab was a student activist from Aligarh Muslim University, and again he arrested on FIR 59. So in uh, June, around 14 June, I think, arrested under the UAPA for the larger conspiracy Delhi Riot case. Trial court September 2020 denied the bail, and 15 June 2021. क्या हुआ network? So next one is Gulfisha Fatima. Gulfisha again the arrested on 9th of April. So Gulfisha have some other cases apart from this UAPA. In May, she is having some FIR 48 on a Jafrabad protest case, but Gulfisha got the bail on May 2020 in Jafrabad case, and then in January 2026, Gulfisha got the bail, and the advocate is Harsh Bora, and Abhishek Manu Sanghvi represented her as a senior counsel. Then Safura Zargat, Safura arrested on 10th of April 2020, and uh, there is a 5 cases currently is going on against the Safura. 4 of them, one of the case is in Jafrabad violence. Rest 3 of the case in Jamia protest or Jamia violence, and 1 case of UAPA. Safura got the bail on June 24, 2020. Currently, Shahrukh Alam is representing her and against the trial which is going on, and basic
Well, it's
counsel
a
is Ritesh Dubey.
discharge application. For Safura, it's a discharge application which Shahrukh is arguing.
Yes. Shahrukh is appealing on the charges. Presently, Shahrukh is mentoring the cases and supported by Ritesh Dubey. Then Tahir Hussain. So Tahir Hussain Tahir Hussain is a person who's in, according to the Delhi police, is the person behind the execution of this conspiracy, and is a member of the conspiracy case. And March 2020, 4 March of 2020, he arrested, and then UAPA cases, and then other cases. So total number of the cases against Tahir Hussain are the 11 cases. 10 cases of the rioting of execution of the riot, 1 case of the conspiracy UAPA, and 1 case of the ED. So total 11 cases against him. In 9 cases the bail. So there is a 3 pending cases against him. One is a UAPA, another one is a pending case in this Chandbagh area, and one is this UAPA represented by senior counsel Rajiv Mohan, and the basic counsel is Tara Narula. Then Shifaur Rahman. Shifaur Rahman against arrested 22nd of April 2020, and arrested from his hometown in UP from Meerut. So Shifa was at the time of his arrest and at the time of the protest, he was the president of Jamia's Alumni Association, and he was handling the Jamia's protest side. So Shifa was arrested against the FIR 59 and all the charges of 307, 124, 153. These are the charges against him. And finally, Shifa have got the bail on January 2026, and Shifa Rahman released, and his basic counsel was Amit Bhalla and Abhishek Singh. Asif Tanha was arrested on 17th of May 2020, and at the time against these Jamia violence cases, and then after this FIR 59 also. And Asif was a Jamia's student in a BA Persian, BA final year Persian student at the time of his arrest, and he had given his examination from the jail, and so Asif got the bail on 28th of May 2020 in Jamia's cases, and then on June 15, 2021, Delhi High Court granted the bail, and presently Asif is having total 5 cases against him, 4 cases of Jamia violence, and 1 case of UAPA. Advocate is against Sojanya Shankaran, and senior counsel is Siddharth Agrawal. Then again, Asif, Natasha, and Devangna have got the bail at the same time. Devangna arrested on 23rd of May, and the main cases against this FIR 59. May 24, 2020, Narwal was released on a bail. However, police immediately arrested her again under different charges. And then she finally got the bail 15 June of 2021. Advocate Aditya Pujari and the Kapil Sipal. So now Devangna arrested on the same date of Natasha Narwal, 23 May of 2020. And Natasha got the bail and then re-arrested as same like Natasha. Devangna got the bail and re-arrested same like Natasha, and advocates were the same, and she got the bail on June of 15 and released on June of 17. Lawyers were Adit Pujari as well as Kapil Sibal, same like Natasha Narwal. Tasleem Ahmed, one of the unknown faces of Tasleem, was arrested June 24, 2020 on FIR 59. Tasleem participated in anti-CA protest and in the resident of Chandbagh area. And Tasleem's bail were denied. Nearby Jamia. Tasleem's wife is now small. Then again, Atahar Khan. Atahar arrested on July 2002. So there is a few cases against Atahar this in Chandbagh area for execution of the right. Atahar formal arrested on July 2, and in between March to April, Atahar called many times by this special cell, briefly detained and then released. In 2000 to 25, he got all bail in all non-UAPA FIRs, but in January 2006, bail have been filed by Arjun Diwan, and we are waiting what will be happen. Then again, Sharjil Imam, everyone knew about the case, so there's and Talib is here, he will speak about it. So these are the summary of the cases, and then the lawyer again, Talib is here, and as well as Ahmad Ibrahim, those who are the basic counsel of him. Umar arrested on 13 September 2002, and then Umar again the same FIR 59, and on December case of
I think we're
the
losing
charges
you.
have not been framed against Umar, and in this case, Kapil Sibal and Tirdeep is a basic counsel, and Kapil is representing him. So still, there is a few friends, those who are behind the bar, those who are Tahir Hussain. Against, I am recounting it. Tahir Hussain, there is a total 13 case against him. 11 of the execution of right. One is a UAPA case and one is a ED case. Rajiv Mohan and Atara Narula is representing Tahir Hussain. Another one is a Salim Malik. The Salim is the person who was a biryani seller at the time of CEA protest. So Salim is still behind the bar, and then Athar Khan. Athar also have not got the bail. Athar was a student activist and one of the co-organizer of this Chandbagh protest site, and then uh, Tasneem Ahmed. So there is a five. One is a Tahir, another is a Tasneem, another is a Salim Malik, and then Tahir Hussain, and then Umar Khalid, and as well as Sharjil Imam. These friends are still behind the bar. In majority of the cases, those who are execution of the violence, like Jafrabad violence, Chandbagh violence, and in all other cases, they have got the bail, but still UAPA is there. So these are the people, those who are behind the bar and those who have got the bail.
Thanks. Thank you, Nadeem. Thank you so much for taking
Thank you. I think it's too long, but sorry for that.
No, thank you so much. The kind of detail you provided is very, very, very important, very useful as far as all of us are concerned. So we get a sense of the people who are still in and the range of suffering which was really caused by these cases, as well as the lawyers who were there. So thank you so much for taking us through these cases. Thank you so much, really. Now let's go to following up from Nadeem's overview of the range of cases, really. Let's go to Talib Mustafa, who's a lawyer from the Supreme Court who has represented Sharjil Imam in a range of cases he had to face. So again, Talib has followed these cases very closely. So Talib, over to you now.
Yeah, thank you so much, Arvind, and hello everybody. Uh, so I'll just briefly, because we have the likes of Ma'am Indra Jaising and also Mahid Desai sir, so they will be absolutely talking about the repercussions of this judgment and how it has completely diluted the Terror Act, which has been consistently defined by different benches of the Honorable Supreme Court earlier. So I would like to mostly confine my conversation about the case and the manner in which this boy called Shajil Imam was implicated and the kind of prosecution he is facing for his anti-CAA, of course, actions that he undertook post tabling of the law in the parliament. So, which I must say, so the way it's starting, it's very essential that the major thrust of allegation against Sharjeel across all his prosecutions, he's facing altogether 8 prosecutions, 5 of them being for the same one speech that he delivered at the Aligarh Muslim University in January. And these 5 prosecutions are across the states. It's in Assam, there's one in Manipur, then one is in Arunachal, then there's one in Uttar Pradesh, and also one in Delhi. So 5 of these prosecutions relate to the same speech that he delivered. The other 2 being incidents of violence at Jamia University during the first phase of riots, as the prosecution call in FIR 59, that there were different phases of riot, and Sharjeel being active in the first and second phase of riots. So there are 2 incidents of violence where he later got implicated in February, and those are, of course, the incidents pertaining to minor violences at Jamia University. And the 8th is of course FIR 59. And to make it clear, Sharjeel remains in custody only in FIR 59, and he has been granted bail, and he has been on bail in all the other 7 cases, 3 in Delhi, and also all the other prosecutions in other states. So we'll see that the first, now in context of course this prosecution in FIR 59, which essentially investigates and prosecutes me for the violence that took place in northeast Delhi or in between 22nd of February to 25th or 26th of February. This is the prosecution in FIR 59. So we will see. So far as my acts in Delhi are concerned, Shajeel's acts, of all the 4 infamous speeches, as everybody calls it, the only of those 4 speeches is one speech that I delivered in Delhi. That's the sole speech in Delhi, of course. That was delivered on 13th of December in 2019. That is almost 2.5 months prior to the unfortunate Delhi riots in February 2020, right? Now, for that speech, of course, there are 2 prosecutions that I'm facing. So before just going back a little and just telling you about the manner in which he got implicated in cases after the cases. So 13th of December is a speech in Jamia University in Delhi. Nobody takes note of it, even though it was very much uploaded by Sharjeel on the Facebook and otherwise on all the social media wherever it was. However, absolutely nobody took any note of it. Then thereafter, came this second speech, which was delivered in Aligarh, and from where, which was delivered in Aligarh on 16th of January, actually. And a portion of it's a very long speech. He was called by the Aligarh Muslim University student committee to speak on what is an effective method of protest in situation like this. So that's the essentially the gathering that he was addressing to. He was essentially gathering on this topic alone, where he delivers a speech which is almost 1 hour and almost 15 minutes long, from where a 40-second clip was taken. This is I'm talking about 25th of January now. The speech is of 16th of January. 25th of January, a snippet, a 40-second video clip from that 1 hour long speech is taken and is put on Twitter by office bearers of one political party and asking for an immediate FIRs and action against him. Now, in that snippet, he seems to be saying that we should cut off Northeast India from India so that our voice is heard. Now, this is only 2 or 3 lines from the speech that they make viral and say that he's calling for cession of Indian territories and therefore absolutely anti-national, and he must be taken to task. Now, as we know, the through series of judgments of different honorable courts, including Supreme Court and High Courts, it has always been said that whenever a piece or article or a speech is under scrutiny, we cannot just simply see 1 or 2 lines from there. We have to see the article or the speech in its entirety and then make a view as to what this speech is all about. Now, however, I mean, because the state functionaries were, I mean, so powerful, and it was amplified at this magnitude on 25th. This snippet, which led to within one day, within 24 hours, this speech getting this snippet getting viral, 5 FIRs within 24 hours in 5 different states got registered against Sharjeel. All these prosecution mostly were for the offense punishable under section 124A, which is sedition, which at that point of time was very much in paper, in book, and of course in law. However, it's now been stayed by the Supreme Court. Now Supreme Court re-examining the validity of the provision of section 124. But most of the prosecution, all these 5 prosecutions were for the offense of sedition mostly, and of course hate speech was there, which is an ancillary offense, of course, but major offense being sedition. Now, so we'll see. Thereafter, only 3 days thereafter, I'm taken into custody from my hometown, which is Jahanabad in Bihar. On 28th, I get arrested. So this fact itself is speaking, in so much as my connectivity or my connection with the Delhi February riots is concerned. I'm in jail already at almost 1 month prior to the Delhi riots of February 2020. And as we see, if we see the case of the prosecution in FIR 59, as also the FIR itself and also the entire charge sheet, the main object of conspiracy, which they say that they are prosecuting in FIR 59, that is this, that these individuals, though nobody is named in the FIR except Umar. Umar is named, but strangely, he is also not made accused in the main charge sheet. He's named, and the allegation is that they have received a tip-off where they have came to know that a conspiracy was being hatched by Umar Khalid and his associates to do something violent during the Donald Trump's visit, so that India suffers an international embarrassment and all of that things were there. Now, one thing was very critical, and as per the own prosecution's case, and this is an admitted fact, of course, that the Donald Trump's visit to India got a final schedule out only on 11th of February 2020. Now, once this schedule only comes out in February, that Mr. Trump is coming on in between 23rd or 25th of February, and therefore we have to do something, do all these riots, cause all these riots, and plan all these riots during that time. by the very fact that I have been arrested on 28th of January, I get completely disconnected from any such conspiracy that the prosecution says that that was conspired post 11th of February. So one thing that is that there is a clear distinction insofar as case of Sharjeel is concerned from the rest of those who are also co-accused in the matter. Now, strangely so, there's one very peculiar thing in there. Now, there is an FIR that I face, which is before the same special court, which is FIR number 22 of 20. Now, this FIR in Delhi is also before the UAPA special court. There is 124A, there is 153A in the prosecution, and also there is section 13 of UAPA. For which I'm being tried now. The charges were already framed, and I'm facing the matter is the stage of prosecution evidence. Now, this FIR essentially prosecutes me from my for all my overt acts since the inception, which is the 5th of December 2019, to the date I get arrested, which is 28th of January. For all my overt acts, I am being prosecuted in FIR number 22 of 20, in which there is no, admittedly, there is no chapter 4 or chapter 6 offenses of the UAPA. Even though there is section 13 UAPA, however, section 13 comes under chapter 3, and therefore the rigors of section 43D5 does not apply. And I'm also on bail in this case. When I was granted bail almost after 4.5 years of staying in custody in that FIR as well, I was granted bail by Delhi High Court. Now it's so what becomes clear is that none of the overt acts of Sharjeel in itself constitute chapter 4 and chapter 6. And this is the admitted case of the prosecution in FIR 59 also. Strangely, what they say while implicating me as an accused in FIR 59 is that it is only and solely on the material that was recovered from Sharjeel's cell phone, essentially the chats and the groups that he made, which was already seized by the investigating team of FIR 22 by 20. This is the case from where I'm originally arrested on 28th of January itself. And they say that they already had recovered all the chats from the digital devices, and it is only on the basis of those chats that the prosecution came to a conclusion that I was somehow part of this larger conspiracy to cause communal riots. Now, it's very, very, surprising, since they say they already had me on 28th of January, and they already had my phone, and they already had all the chats and all the groups that I am in. So therefore, the natural conclusion was that they could have unearthed the conspiracy mostly immediately after my arrest because they had all the materials. Now, but no, I do not get arraigned as an accused in FIR 59, even at the time of filing of that FIR, which is in March, almost 2 months after my arrest. Not even in the main charge sheet, which is filed another 5 months later, which is almost 7 months from my arrest. The first person to get arrested and the first person of whose digital devices and phones that the prosecution had, and today in the charge sheet that they say that it's the same material on the basis of which they have implicated me, then how come this investigating agency for 2 months almost, or for almost 1 month prior to the Delhi riots FIR, even having the same material, and they were absolutely not able to do anything or to unearth the conspiracy that they claim that there was. So that's a little strange. So I ultimately get implicated in FIR 59 only in September or October of 2020, which is almost 7 and 8 months later. And the reason is, of course, that as I've already said, that the only reason was that the chats led them to the conclusion that I was part of the conspiracy. However, very strangely, and this is the argument that we put forth before the court also, but however, it has not been considered at all in the judgment that has been delivered. Now, when they say that the sole material on the basis of which they have implicated me is chats, strangely, there is absolutely no chat of Sharjeel with any of the co-accused. While all the others, there is a connectivity chart, which is part of the chart sheet, where all the co-accused and co-conspirators are found to be somehow connected with each other over messages or over calls. Strangely, the only one who is not connected with anybody at all with none of the co-conspirators or co-accused, as the prosecution alleges. And the same chats, even though there is nothing, no chats with anybody, no chats pertaining to any violence. However, prosecution files a charge sheet against me on the basis of chats, which was quite strange. So what we put forth before the court was that in a case of conspiracy, which they are saying that I have been implicated to solely by the sweep of 120B, where is the prima facie material to indicate that I was part of any conspiracy? Absolutely not. There could be 100 people fighting against the protest, but that does not mean they have come in conspiracy or they have come in agreement with each other to do something. They could be independently pursuing their cause, as so much of us were not really being bound or being in agreement with each other. We're acting and raising these protests or coming out to protest, but individually taking up different calls. So that was one thing which was very missing. Secondly, one thing that I also want
Talib, can you be louder? People have been
voice is not
saying
clear.
for a while.
Very well. I'm so sorry, ma'am.
Yeah, I mean, very valuable what you said, and a lot of people are saying you're not audible. So please, at least henceforth.
Am I audible now, ma'am? Am I
Yeah,
audible? Right.
yeah, at least to me.
Right. Right. So this was essentially, I mean, broadly on merits as to how Sharjil's case was much different from any other, because he was completely disconnected in time, in place, and with all other co-accused persons or co-conspirators, as they call it. So far as my prosecution in FIR 59 was concerned, but all of which has absolutely not been considered in the judgment at all. Rather, what they say, the judgment says that my dismissal is because of the fact that I along with Umar was the first ones to act once the cab was put on the table in the parliament, and through our speeches we essentially gave everybody that that ideological philosophies that we spread through our speeches and all, which was most problematic. But he did absolutely avoided going into as to whether the speech in itself constitute chapter 4 or chapter 6 UAP offenses or not, even though, I mean, and there are no such findings that the speech alone would of course attract section 15 UAP offense, and especially when there are absolutely no findings, and there are no findings across courts, not just Supreme Court, but all the dismissals by High Court, all the bail dismissals by the Special Court, absolutely no finding anywhere that any of them call for any kind of violence in their speeches. Rather, there are judicial pronouncements in cases of Sharjil, whether it's the Allahabad High Court order or whether it's the Delhi trial court order, which has been completely not dealt by the Supreme Court as well, where the court goes on to say that there is absolutely no call for violence in any of the speeches that the Sharjil delivered, and also this fact that there was absolutely no consequent violence post my speech delivery. And these are the findings across every state. So I deliver 4 speeches. One I deliver in Jamia, which is in Delhi. In Delhi, I am granted bail in that case after court having found that there is absolutely no link between my speech and the violence. Aligarh, which is the most harshest speech and the most relied upon speech throughout the charge sheet, the Allahabad High Court grants me bail after having found that on an undisputed basis, there was no call for violence in the speech, and there has been no violence because of my speech. Now, these are the 2 places. The 3rd and 4th speeches are in Bengal and Bihar, where there is absolutely no FIR registered, no public order issue actually arose on those areas, and therefore absolutely no prosecutions there. However, on the basis of the same speech, now Sharjil has been implicated for violence that took place almost 2.5 months later. So absolutely, I mean, doctrine of proximity, I don't know where it goes. Several judgments of Supreme Court, including the 3-judge bench of in S. Rangarajan, and prior to that in several other judgments also, for that matter, even in Kedarnath Singh, and further again in Shreya Sangal, the doctrine of proximity, which was propounded by all these judges based on several jurisprudence, has completely given a go-by while deciding this case, and the implication of the speeches that the Supreme Court was seized of while deciding, with the complete miss out over there. Now, these are the basic facts on, the basic things on merits that I wanted to highlight. Apart from that, taking aside the case on merits, some of the things which are self-speaking and which are very strange is just I wanted to highlight within 2 minutes if I can do that. If I am not, I'm so
Can this wind up in 2 minutes? If
very well.
possible? Yeah, thanks.
So just I will in these 2 minutes I just want to touch two brief topics that I wanted to take. Firstly, that we have to see the history of this case, which I would like to just sum up in one minute maybe. So we see that 3 of all these accused persons were granted bail. Firstly, in the year 2021 and 2022 itself, 3 of the co-accused persons, Devangana, Asif, and Natasha, they were granted bail on merits by Delhi High Court, which was ultimately affirmed by the Supreme Court. In that judgment, Delhi High Court goes on to say that there is absolutely, in this entire case, no case of UAPA is made out at all. You may prosecute them for IPC offenses or under the ordinary penal provisions, of course, but absolutely no case of UAPA. Now, strangely, this judgment was delivered by Justice Bhambani and Justice Mridul way back in 2021-22. But strangely, when another set of co-accused persons came to High Court, strangely, even though the second junior judge, Mr. Justice Bhambani, was not part of the bench, however, the other senior judge was very much there. So essentially, the same judge took a different view in the matter and found the case to be prima facie too, attracting UAPA provisions in this entire context. So, this was something which absolutely none of us were anticipating, and it was quite strange that the same judge will take a different view in the matter once they had taken a very, very clear view way back in 2021-22. And second thing, sir, and that's one thing that I just wanted to touch, and that was that in this judgment, you, sir, must have seen that somehow, even though not very elaborately and not very clearly, Supreme Court has dealt with the issue of Article 21. Of course, it dilutes Najib and all of that. However, but so far as the facts of the case were concerned, they have not very clearly dealt with that. And one thing that I just wanted to bring to your notice is that, however, there were almost 1 month or 2 months of delay that has been caused by the accused persons during this entire time when the arguments on charge were being pressed by the of course the accused persons, and this period ranges from September, October 2024 till today, of course, because in this time the charge arguments were happening, and a delay of 1 month could be attributed to our accused, even though those were unintentional and rather small accommodations were sought where adjournments for 2 days or 3 days were given. However, court had made comments on that, saying that these things show that somewhere prosecution is not the one who is to be questioned for the delay. Rather, there is some delay on the part of the accused. But court completely forgets to take note of the fact that where the law mandates them to finish their investigation in 90 days, and in cases of UAPA, 90 plus 90 days. So therefore, then as per the law, they were supposed to finish the investigation within 180 days, which they didn't. They rather kept on filing charge sheet after charge sheet till July 2023. So for 180 days, which the law contemplates that they have to finish the investigation within that period, for the 180 days, they took 3.5 years, but absolutely no comment by the Supreme Court insofar as this issue is concerned. Thereafter, from July 2023 to almost October 2024, it's when accused persons, because this is the same time when the accused persons' bail applications were pending before the High Court. Now, before the High Court, the case of the prosecution was that the investigation is still undergoing. So therefore, at this stage, I don't think they should be granted bail. This was the argument before the High Court. However, when some of the accused persons filed an application before the trial court saying that arguments in charge can only proceed because Delhi High Court says that there has to be a clear statement from the prosecution before proceeding with charge that the investigation against all the accused persons has finished. But because at that point of time, their interest lied, because in High Court, they had to say that the investigation is still pending to somehow curtail our right to bail. So therefore, for 1 long year, this statement was not given by the prosecution, and ultimately in September or October 2024, they gave a final answer to the special court saying that investigation against everybody is now of course, concluded, and this is after a detailed and on merit application decided by special court, saying that the prosecution was obligated to tell this fact before proceeding. So this 1 year of another delay from July 2023 to another 1 year was entirely attributable to the prosecution, which again was completely given a go by the Supreme Court. With that, I will just wind up and leave it for the other speakers.
Thank you so much, Talib. That's really very educative in terms of the detail you took us through in terms of the Shajil's case and the details which we should all be aware of now post the way you explained it all to us. Thank you. And I think all of this needs a lot more time. Really apologize for cutting you short, but really we have to be able to see how we can bring this discussion together. Without further ado, and now invite Ms. Indra Jaising, Senior Advocate of the Supreme Court, to really address us today. Ms. Jaising, as all of us know, is the Senior Advocate of the Supreme Court of India, and she's also a very important public intellectual in the Indian context. And on the question of Umar Khalid in particular, there's a piece which Ms. Jaising written in the leaflet called "Shadows of Judicial Indiscipline on the Supreme Court's Bail Denial to Umar Khalid and Shajil Imam." I request everybody to please read that. Ms. Jaising, the floor is, I hand over the floor to you now.
Can you just give me a minute?
Yeah, no.
Just a second.
So I've just put that list. Yeah, Ms. Jaising, go ahead.
No, go ahead, Kavita. You wanted to say something?
No, I just said that I put the list that the total of 18 people, 11 are out, 7 are still in, and we need to track, the 7 who are in, because they may find it very difficult to come up.
Okay. Arvind, you were saying something, or should I start?
No, please start.
Okay. So thank you for this opportunity. I agree with Arvind. It's been very educative listening to the previous speakers. The facts relating to this case, which is commonly known as the Delhi riots case, have always befuddled my mind, because ever since I've been reading about it, I could never see what exactly was meant by the prosecution in saying that there is a terrorist activity or a terrorist act, as Section 15 requires. The heading of Section 15 is a terrorist act. Now, commonly understood, the word act means that someone has to take some action. It's a physical action. It's not a mental act. It's not a thought which passes through your mind. So before anything else, I want to say that all criminal laws address overt acts. They do not address your mind. I can be sitting in my living room and dreaming about a revolution coming in India through violent or non-violent means. It doesn't make it an offense, because there is nothing known as thought crime in this country, or indeed anywhere else in the world. There is nothing known as thought crime. All crime addresses overt acts. That's the first point we need to know. So the question arises, what is the difference between one crime and another crime? And when is a crime a crime? That is something that I'd also addressed in the article. Now, then we will raise the question, what separates crime under, say, IPC and a terrorist crime? That's another question that we all need to answer for ourselves. So one distinction I've already mentioned to you, all crime addresses only overt acts. That's the first point to remember. The second point to remember is crime is graded. Obviously, crime is what society considers criminal. It's very much of a social construct. What is a crime and what is not a crime? Thirdly, you can take it for granted that, yes, all violence in some form or the other becomes a crime. So there's a clear distinction between violent and non-violent, say, right to association that Arvind was talking about. The distinction between violence and non-violence is indelible. And one has to remember that anything that is non-violent is not a crime. Now we come to the third question. Assuming there is violence, what is the crime that is being committed? So, crime is always graded according to the degree of the violence, the severity of the violence, and dependent on that is the severity of the punishment. So, one might argue that in all criminal law, there is a hierarchy of violence. There is an hierarchy of punishment. And this is the reason why I have been arguing that all riots are crimes, but all riots are not UAPA crimes. So when one talks about Delhi riots, yes, since our law college days, we have been taught that a riot is an offense. It's a crime for which there is a definition in the Indian Penal Code. But when does a riot become an act of terrorism? And in my opinion, the answer can only be never. Now, why do I say never? Because, of course, a riot is very clearly defined as an unlawful assembly of 5 or more persons who indulge in violence. Fine. But why do I say that a riot simpliciter cannot be an act of terrorism? For that, of course, we need to understand what is terrorism. So, what is it? Have we addressed that question? If not, it's time to address it now. So, three things that characterize crime. One is motive, one is intent, and the other is the overt act. So we have already discussed the overt act. Now let's discuss motive and intent. So when it comes to motive, the motive of a terrorist act is either political, and political understood very broadly, or it's ideological, where ideological and political can overlap, or it is what is sometimes described as religious. And there is a motive of coercion involved in it. Now, you just compare this with an ordinary riot, okay? An ordinary riot is something which the motive is to cause harm to the person who is being beaten up or murdered. Let's say I commit an act of murder. I commit an act of murder because I want to murder that person. Period. It ends over there. We come to there is no ideological reason for me to murder anybody. There's no political reason for me to murder anybody, and there is no religious reason for me to murder anybody. I can murder you because you stole my cow, or I can murder you because you had an affair with my wife. It's a very personal motive. And it is a crime. There's no doubt about it. There's an IPC crime. You can also have life imprisonment for things like that. But beyond that, there is nothing else that you can point to. Then you come to the question of intent. Now, when you come to the question of intent, there is a clear intent to create widespread, what they call terror. Now, what is the meaning of creating widespread terror is also not known. But, or to create intimidation, or to coerce the government, or to do or not to do a particular thing which they are entitled to do. Now, that is an integral part of the definition of terrorism. And then there is the question of impact. So, when it comes to impact, the impact is intended to be against the citizens of a country or the residents of a country. Okay, so it's impacting a person who has nothing to do with you. It's random, completely random terror, random violence. That is what terrorism is. And at one point, you can say that it could be something like hostage taking also. Now, what we have to understand is that there is no, for example, there's no international convention on counterterrorism. which would define what is terrorism. And I understand that the reason why there is no international convention on the subject is within the international community, there's a huge debate on what is the difference between legitimate liberation movements and terrorism. There has been no consensus on this, and that is one of the reasons why we have not had an international convention on what is terrorism. And the world community has not been able to agree on what constitutes unlawful violence, meaning that there can be lawful violence as well. For example, the right to self-determination. Then there has also been no consensus on the role of non-state actors or even violence unleashed by the state. And that is one of the reasons why there is no. Now, so where is all this coming from? And if this is the case, then from where are we getting all our anti-terror laws? So it all began with what the United States of America called the War Against Terror. It begins in the 80s, but it takes a very sharp turn. So let me give you a few examples of scattered international conventions dealing with the issue of terror. There are conventions relating to, say, crime committed on aircrafts. There are conventions on crimes relating to conventions on acts of terrorism committed against civil aviation, against naval ships, against civil aviation, I've already mentioned. There are conventions on taking hostage. There are conventions on nuclear facilities, violence against nuclear facilities. There are conventions against maritime, crime on maritime ships, I've already mentioned, on fixed platforms, on terrorist bombing, there's nuclear terrorism. These are the different, so from this you draw examples of what terrorism could be, okay? So obviously when you attack a nuclear facility, you're sending a message. You're sending a message to the state, you're sending a message to the citizens, etc., etc. Now, my contention is that judged by any of these parameters, the riots which took place in Delhi cannot be described as acts of terrorism. Yes, they can be described as crime simpliciter. So we come to the crucial question, which is really not so much of a legal question, but a more of a political question. Why do governments invoke UAPA? Now they invoke UAPA only because of the solitary change in procedures for conducting investigation and trials that has been put in place in India in UAPA, beginning with 1976, after which we get an amendment in 204, where Chapter 4 gets added after the repeal of POTA. After that, we come to an amendment in 2008, where we get a further amendment, and then ultimately 2019, where individuals can also be declared as terrorists. 2008 concerned the issue of funding terrorism, and perhaps even this economic security was introduced during that period. And please note that some of the amendments have been made, some of the very draconian amendments have been made by UPA governments, not necessarily by the BJP-led government. So that's insofar as, to come back to the issue, the only reason why it's a double whammy, a combination of two factors which lead to the invocation of UAPA, not because you fall within the definition of terrorism, but because the state then acquires the power to prosecute as and when and how it pleases, which is generally extending the period of investigation. It is generally denying bail, critically denying bail. And thirdly, I have not come across a single case of UAPA where the issue of conspiracy is not raised. Very, very important. Now, when is conspiracy normally raised as, added to any group of offenses? You've been given a presentation on what were the offenses against each one of these individuals. And of course, you have all the agram shagram offenses under the Indian Penal Code, grievous hurt, serious hurt, riot, murder, etc., and conspiracy. Now, the offense of conspiracy is always included in a group of offenses when there is no evidence of an overt act. Why? Because the all that conspiracy requires is an agreement. It does not require an overt act. So now you see the whole link. The chain is very clear, beginning with no overt act, going on to no motive, going on to no intent, going on to conspiracy, all leading up to one factor alone, denial of bail. So that is one thing. And this morning when I was, and this is not peculiar to UAPA, it's been introduced in many laws, and PMLA has the same chain. And so there has been an increasing tendency in Indian legislative patterns to depart from the CRPC. So when one is looking at the criminal law of this country, one is almost forced to look at the so-called specialized laws. Now, in my opinion, these laws are also vulnerable. At least in PMLA, so many of these changes were introduced via money bills. Now, this is again one way of bypassing the upper house. And I don't understand how a crime can ever be introduced as a money bill. The issue is pending decision in the Supreme Court of India. Now, this being the position of law, the question, it seems to be very clear that the Supreme Court has failed in its duty to understand fundamentally what is the meaning of terrorism. And I have said, and I have written, and Arvind has drawn attention to that article, that this judgment actually expands the definition of terrorism. In any case, the wording of the sections that you see in these laws, if you look at the definition of unlawful activity in the same statute, UAPA, you'll find that it covers lawful and unlawful acts. Now, most importantly, I forgot to mention that when it comes to terrorism, if you see section 16, there is 15, there's a direct reference to undermining the sovereignty and integrity of India. Now, where I heard all the presentations that were made by the previous two speakers, where is that element in this case? It's absent, it's missing. There's no reference to undermining the sovereignty and integrity of India, except that the government of India seems to be peeved, like a child would be peeved, at the protest taking place when Trump was visiting India. That's about it. But other than that, there is no other reference to now. If demonstrating during the visit of a foreign dignitary amounts to attacking the sovereignty of India, it's like I've always been asking this question to everyone I meet. Can you explain to me whether defaming India is a crime? In my opinion, it is not. So these are three expressions in recent times that I have heard, which have no legal content, no legal meaning. One is urban nutshell. The other is defaming the country. And the third is anti-national. These three have no definition in Indian criminal law. And yet they're repeatedly used in every single narrative. The tragedy, of course, with this judgment is that what you call You may call it common sense narrative, when common sense is actually glorifying the narrative, but it's a narrative which has been successfully sold, which has now become part of the jurisprudence of the Supreme Court of India. And this is what we need to be very afraid of, because it's very clear that judges are now delivering their judgments based on narratives that are being sold to them by the prosecution, and this is where we need to be afraid. And as I said, I would just like to end by saying, if you read Section 13, which defines unlawful activity, the section itself is a catch-all section which includes within it illegal and legal activity. That's the problem. Okay, so one might accept for a moment that secession and secession is activity which you would say impacts integrity and sovereignty of India, but this section goes beyond that. And therefore, this combination within one umbrella of activity which is legal and illegal is what enables the prosecution to bring fake charges. And we've heard from all the previous speakers what the charges were, and it would have been nice to hear about it in a little more detail. But since there's a written presentation, we can study the written presentation later on and make up our own mind whether we finally, there's only one more thing that remains to be said, and one of the arguments raised, of course, is laughable, which is that the intent, if you go through the three categories I mentioned, motive, intent, and impact of this activity, was regime change. Now, again, one has to ask the question, what is the definition of regime change? Again, you will find none. And again, you will, apparently regime change is either, it's normally happens, I'm told, through external forces external to the country. So what happened in Venezuela, you can say, is a regime change. Okay, where America comes in and just picks up the president and walks away with the president. Yes, that is targeted at regime change. So the expression regime change is normally associated with external, but when it is internal, it is associated with an insurrection. So I don't see any allegation of any insurrection over here. And that they're able to successfully tell a story like this, and much has been written about the fact that the charge sheet contains no such allegation. And the senior counsel appearing on behalf of the accused did tell the court that there was no allegation of so-called regime change in the charge sheet. How could they successfully so basically, I think argumentation strategies, I'll stop here by saying that basically argumentation strategies need to deconstruct these definitions and explain to the court that you tell us, we are happy to be enlightened on this issue. You tell us, what is your definition of terrorism? There's no discussion at all. Not in this judgment, not in this Gulfashar judgment. And how the facts alleged, even if you take them fully at their face value, that is my point of view. If you take these facts at their face value, they will not constitute offenses of terrorism. At best, the actors in these cases, those who were physically present, those who were found to have indulged in overt acts, might be guilty of something like a riot, for which they would have to be governed by ordinary principles of CRPC. So let me stop by saying the motive is very clear. The motive is to introduce procedures for investigation which go contrary to the guarantees in Article 21 and of the Constitution of India. Stop over there.
Thank you, Mr. Dissent. And I think it was very useful to have placed a frame on the previous discussion. The previous two presentations really gave us a sense of the factual content of what is going on, as well as the legal issues within which the anti-CAA protesters are presently being sought to be framed. And the frame you provided us is how to think about the entire question of terrorism within using the language of motive, intent, overtact, and impact. And I think it's a very useful frame to, as you rightly put it, to deconstruct the notion of the offense with which the protagonists are charged with in this particular case. And I think the larger point which is implicit in the argument you're making is the question of the repeal of the UAPA. Should the UP this is the time come for a campaign to repeal the UAPA is a question which I think the presentation in effect raises. Thank you very much really for that presentation. I'd like to now invite Mihir Desai to address us now. Mihir Desai again needs no introduction, the senior advocate and vice president of the PUCL. And perhaps since we're on the same thematic, I should just mention that he's recently written an article in again the book edited by Anand Teltumde called the book is called Without Human Rights in India, and the article Mihir has written is called Supreme Court and Human Rights. So what seems to connect Umar Khalid, Mihir Desai, and Anand Teltumde is this particular book. So without further ado, Mihir, the floor is now yours.
Hi. Can you hear me?
We can hear you. Yeah.
Okay, fine. Great. Well, Arvind, I mean, just an aside, amongst the many books which are in your background, the only book whose title I can read is Hitler. Now, I don't know whether it's deliberate or otherwise, but and that says its own story, I guess. Well, the earlier speakers have covered a huge ground, and so not much is remaining for me to cover. So let me just briefly outline the 6 ways in which the present decision of the Supreme Court, is likely to affect future cases and moves away from the established law on the subject. Obviously, nobody wants the harsh conditions as they are in 43D of the UAPA. So those harsh conditions should go away altogether. But even by retaining those conditions, there have been exceptions which have been carved out over the years. And those have now been, diluted by this judgment. So I just wanted to quickly go through those 6 things which I feel are issues on which the Supreme Court has really gone berserk, to say the least. So the first thing, of course, everybody knows is the aspect of delay, because the Supreme Court has since last many years been releasing people on the ground of delayed trial under UAPA, PMLA, similar laws, on the basis that right to speedy trial is a part of the fundamental right to life. And so a statute which is in operation, 43D5 in this case, cannot override that fundamental right of a speedy trial. And if your trial gets delayed too much, then your right to life gets violated, and therefore you have to be released on bail. The Supreme Court has time again also said, and this is not just said some 10 years back, but in 23, 24, 25, time and again the Supreme Court has said that, look, the nature or the gravity of the offense is not relevant when you are considering the speedy trial bit. When you're considering Article 21, it's a fundamental right. When you're considering that, you are not really concerned with what is the gravity of the offense. Whatever may be the gravity of the offense, you can't keep somebody who is presumed to be innocent. And that presumption of innocence also goes under the UAPA. It doesn't get, replaced. Till you are convicted, there is a presumption of innocence. So you can't keep people behind bars for long periods of time on the basis that because the trial hasn't started. And in this case, obviously, the trial hasn't started. And if you look at, for instance, the Delhi riots are not done under the NIA, but for instance, the Bhima Koregaon cases, which are done under by the investigation prosecution is being done by the National Investigating Agency. The NIA Act itself provides that you have to complete the trial on a day-to-day basis if you are charging somebody, if you are investigating under NIA, the Sessions Court is required, the Special Court is required to complete the trial on a day-to-day basis. That's what the law says. And Bhima Koregaon, where NIA is investigating, it's more than 6.5, 7 years. Okay, more than 7 years actually. And the charges are not framed. Forget the trial starting on a day-to-day or a year-to-year or month-to-month basis. That's not happening. Okay. So the first thing is dilution, saying that delay will be considered only if you are a foot soldier, according to the Supreme Court, and not the planner, not a person who is the ideologue of the thing. This distinction is completely away from the settled law of the Supreme Court. So that's one thing which we have to bear in mind. That's point number one. Point number two is the whole definition of terrorism. I will not expound on that because already the speakers have spoken about it, that how the definition of terrorism is widened. Okay. But what is also important is the third point, which is the actual judgment does attack freedom of speech, but judgment also attacks freedom of association, which is equally a fundamental right under Article 19. Okay. I mean, all my life, I've been chakka jam is a normal term which is used. Chakka jam, when you have bunds called by political parties, these are nothing else but chakka jams, and they call it a chakka jam. So chakka jam is something very, very normal, it's part of the culture of Indian protest movement. Okay, and now you are converting chakka jams, forget chakka jams, even saying that there should be chakka jam into a terrorist act is itself something which is very, very, I mean, it's alarming. Okay, because any kind of protest, peaceful or not, okay, will now be treated under this law, okay, under this judgment, as something which is, which is a terrorist act. Okay, because it will affect, why? Because not because necessarily it will lead to violence, because it will affect the economic situation in the country. Okay, now a chakka jam, a normal peaceful chakka jam, a normal peaceful bandh for a day, a normal strike in a public sector or even a big private sector company is bound to affect, to a certain extent, economic situation. Okay, by this definition, now what is sought to be done is include all those activities in under the regime of terrorism. So that's the second and third thing, that the association. The fourth thing is the question of assessment of evidence. Now look at it this way, that Watali, which is one of the earlier scandalous judgment of the Supreme Court, okay, in which the Supreme Court said that at the time of bail in UAPA cases, you are not to look at what the defense evidence is. You are only to look at what the prosecution is saying, and presumably go by the prosecution case. And if the prosecution makes out a case, matter ends there, you don't get bail. That's what Fatali said. That was diluted, and that was interpreted rather in Vernon's case and some other cases, which says that yes, that's true, that you don't look at defense evidence, but when you are looking at the prosecution evidence, which they are putting forth, the minimum thing you have to do, okay, this is what the Supreme Court says, the minimum thing you have to do is look at the probative value of that evidence. Is it something which is at all likely to be, accepted in the court at the time of trial? If it's purely hearsay evidence, it's never going to be accepted. So if at the trial it is not going to be accepted, why do you use that to deny bail to people? So what now this judgment says is that the present judgment, that probative value is something we will not go into. We'll just accept what the state says, and that's it. Okay, that's the ipse dixit. That what a state says, that somebody has committed a terrorist act. They have put some one or two documents here, and the fifth thing, that's what I wanted to come to here. The fifth point is the whole question of protected witnesses. You see, in this case, for instance, everything which has been linked to violence is on the basis of what are known as protected witnesses. Okay, protected witnesses under the UAP are those witnesses whose names are not known till the trial begins to the accused. So you have no way of countering what they are saying. Okay, because you will get some 10 protected witnesses who say many things. We don't know who their names are. We don't know who they are. Okay, there is no way to defend what against what they are saying. And what is more, and on the basis of this, on the basis of people who are not even known to me, whose names are not known to me, you are denying me bail. What is most important is, like, for instance, in many of the UAPA cases, okay, bails are denied. I mean, this is happening in Ahmedabad, the bomb blast case, which is presently going on in the High Court. There were 39 people have been sentenced to death. Okay, a number of people were denied bail over the years on the basis of what the protected witnesses said. About 7 witnesses, protected witnesses, they relied on. Now, 5 of those protected witnesses were not even brought in for evidence. So you don't even know whether they existed or they did not exist. Okay, they were, I mean, they were not even put up in at the time of trial, saying that this is what the protected witnesses say. Okay, so this is the other problem, which and in this entire case, protected witnesses are the ones used in order to deny bail. And finally, what I wanted to say, the 6th point, is the conditions of bail to people who have been granted bail. The 5 persons who have been granted bail, the kind of conditions of bail which are put are unprecedented. Okay, and are actually, those bail conditions are themselves in violation of fundamental rights. It's one thing to say that you will report to the police. Twice in a week to report to the police? Why? For what purpose twice in a week? Investigation is over. Everything is over. You will be called to court from time to time when the matter is going on. Why should you report to the police at all? Okay. Or if you have to report to police, sometimes they put conditions that once in 2 months, once in 3 months, you report till the end of the pendency. Twice in a week, the person can't do any job. Person can't work. That's one thing. Second thing is, it says that you can't participate in any protest, not just CAA related protests. Any protest you can't participate in, and you cannot distribute any pamphlet, you cannot distribute any leaflet, you can't write anything on your social media. So virtually, it's a kind of a civil death. While granting criminal bail in a criminal matter, you are ordering a civil death to a person. That is what these conditions of bail are. The only positive thing with which I would like to end is, on the very next day, on 6th of January, the Chief Justice's court, Chief Justice of India's court, granted bail to a UAPA accused purely on the basis of delay. Okay, saying that there is a delay of 4 years, matter ends, you are being released on bail. Okay, so obviously this judgment, while this judgment is draconian, okay, there are ways in which Supreme Court itself is trying to find a way to circumvent it, and I hope that ultimately this judgment is completely overruled. That's all. Thank you very much.
Thank you, Mihir, for taking us through the various infirmities as far as the judgment is concerned. I think very important for all of us to try and understand what the actual infirmities in the judgment are, because at the end of the day, the history of personal liberty is really the history of the insistence on procedure, which is what Justice Khanna said in his ADM Jabalpur dissent. So it's very important for us to understand exactly how our liberties are being denied by the court in this particular case. And thank you again for concluding on the note of hope, because again, the point you mentioned is the Najib judgment is authored by the current Chief Justice when he was not the Chief Justice, but the Chief Justice's court is now taking this question of delay and granted bail seriously. Then that's a glimmer of hope as far as the bail question is concerned. So we have two last parts of the program. One is the PUCL position paper, which Lara will briefly point out to. And after that, we want to really give the space to people who are in the room to really share their thoughts, to share their thoughts, to maybe express themselves, because we see also this as a forum for the expression of solidarity with respect to the range of what we call prisoners of conscience in jail as of now. So I request all of you to please hold on while we quickly finish this last section and then move on to the audience for sharing of their thoughts and comments, as it were. Lara, the floor is now yours.
Thank you, Arvind.
Just 1 minute. Ms. Jai Singh would like to leave. So surely we can excuse her. She's been sitting 90 minutes. Yeah. So
thank you, Ms. Jai Singh. Thank you.
Ms. Jai Singh, it'd be lovely. Yeah, if you continue, it's lovely. But since it's been a long period, yes, you can excuse. Please go ahead, Lara. Sorry.
Thank you. Thank you, Arvind. the presentations of the speakers have brought out all the anomalies in the judgment. And as PUCL, of course, we are quite appalled by it. And um, the judgment, which has ignored said precedent, broadened the scope of terrorism to include acts of civil disobedience and democratic protest, we believe require judicial review and scrutiny. The most important factor which I wanted to actually add is, while the Supreme Court has denied bail to Umar and Shajil and tried to give credence to and abort this set narrative which Indira Jai Singh also spoke about, um, by giving this state narrative, this set narrative, credence in the judgment. Uh, on the other hand, there's the same courts which did not hear the challenge to CAA, which had been filed by several citizens for all these years, even back then when these protests were ongoing, and also did not prosecute the real instigators of violence, who were the BJP leaders, uh, Anurag and Kapil Mishra and Anurag Thakur and several others, who had made calls for violence um, before the Delhi riots took place. And when the Delhi High Court tried to take the matter up, as we all recall, the judge was transferred overnight. And those prosecutions, I mean, today, one of them is a law minister of the Delhi government, and they have been, given positions of power, while on the other hand, those who are involved in protests, and at most their offense can be of, promoting and propagating means of protest against an unjust policy of the government. And by no stretch, and there is no proximity to the Delhi riots or the violence, the communal violence that occurred during the Delhi riots, to their speeches. Even if we look at it by any stretch of imagination, we see the way in which the court has has played a role in turning the table. So I think this is one of the most appalling aspects that we all note. And this judgment is one in a series where both of these, as well as five others who are still in jail in this case, have been denied their liberty. Some of the points that we have made, and the position paper is long, and I recommend everybody read it. Many of the points that have been raised in today's today's program, as well as the points made by Mihir on the judgment, all of them are part of the position paper. But in conclusion, some of the points that we wanted to point out, I'll just very briefly state. PUCL is disturbed with the unconstitutional ruling of the Supreme Court, which not only undermines the rights of the accused activists, and we have spoken a lot about the rights of the accused activists, but it also serves as a blow on the right to dissent and protest of citizens. This precedent that has been set, this definition of terrorism that has been enlarged, is a big blow for our right to protest in our country. For our future protests as well, for future cases of UAPA, this broadening of the definition, where any kind of organizing and calling for protests can be criminalized. It may be criminalized. At least that scope has been now provided, which is a very, very worrying factor, especially in the context where human rights defenders are being criminalized in the country. We have seen a clampdown on journalists, on civil society organizations through the FCRA process. We have seen RTI activists who have been targeted. Similarly, so many are still in jail under different draconian laws. Surendra Gadling is about to complete 8 years in jail without bail in the Bhima Koregaon conspiracy case. Sonam Wangchuk, climate activist and protest leader from Ladakh, is facing similar incarceration following his arrest on trumped up charges under the National Security Act. We also have recently, the environmental activists Harjeet Singh and Jyoti Awasthi, co-founders of Sasat Sampada, whose houses were raided by the Enforcement Directorate. So we have seen a lot of, these actions against human rights defenders, and this, is in the same line of actions against human rights defenders, protesters, and those who have dissenters of, government policy. The judgment will also have implications on all those who are trying to take forward the ideals of the Indian Constitution. All detainees under UAPA face a chilling prospect of indefinite detention. Uh, since the Supreme Court has legitimized the idea of process as punishment, the Indian Constitution under Article 19 guarantees the right to freedoms to all citizens that enable us to adopt democratic and peaceful means of protest. This guarantee of freedom is a promise of independent India. It forced the British colonial rule to attain the people's rule as a democratic republic. We're a signatory to the ICCPR, which by which the Indian government is committed to uphold the rights to free speech, assembly, association, and movement of all citizens. We have also ratified the UN Declaration on Human Rights Defenders, which is the declaration on the right and responsibility of individuals, groups, and organs of society to promote and protect universally recognized human rights and fundamental freedoms, adopted by the UN General Assembly in 1998. And it recognizes and protects the rights of individuals, groups, and organizations which are working to promote and protect human rights, or to strive for the protection and realization of human rights and fundamental freedoms through peaceful means. India is required to, stand by its commitment to the UN Declaration on Human Rights Defenders and strive to promote their well-being and to protect them. But what we are seeing today is the entire opposite. What is being criminalized today is the expression of political ideas. The associations people form to express these ideas and assemblies people participate in to take forward these ideas. The fact that Sharjeel and Umar are in jail for their ideas, for associating with others to take forward those ideas, and for being part of protests and demonstrations, this is what makes them prisoners of conscience. Prisoners of conscience are persons imprisoned for the peaceful expression of their political, religious, or other conscientiously held beliefs, or for their identity, even though they have neither used nor advocated violence. And we know from all of these speeches, they have neither advocated violence, and there is no proximity to the violence, so there is no question of them using violence. What makes their imprisonment even more telling is that the ideas they are advocating are the ideals of equality and non-discrimination in the Indian Constitution. Are we then supposed to conclude that state which imprisoned them has no more faith in the ideal of equality of all regardless of religion and is therefore imprisoning those who continue to believe in equality? Our ideas cannot be silenced, and as Father Stan Swami had eloquently put it, a caged bird can still sing. And so PUCL hopes that we can stand in solidarity with Sharjeel and Umar. And the song of equality sung by Sharjeel and Umar continues to resonate with us. It is our demand that the Indian government stop reprisals on all human rights defenders, prisoners of conscience, and ensure the enactment of law for protection of human rights defenders from unjust persecution for taking up human rights issues and exercising their right to protest. We are also renewing our demand for the repeal of the draconian UAPA that tramples upon the rights of accused to fair trial and that has served as a tool of repression and criminalization of the right to protest. And for this purpose, we cannot leave it to the state alone because they are not going to act on these demands unless a large section of civil society come together to oppose this draconian law. And like-minded groups, parliamentarians, and political parties need to come together to form an alliance against this brazen abuse of power and work towards the repeal of the UAPA law as it violates the right to life, speech, assembly, association, as well as the right to a fair trial. We need to work with people across the sections, whether they are jurists, whether they are lawyers, whether they are journalists, whether they are activists, whether they are teachers and scholars. We need to come together in order to fight this law which is being used against dissenters. And we have to advocate both nationally and internationally that Indian state complies with the ICCPR and UAPA, which is, which main purpose is to target human rights defenders, which main purpose is to do away with processes that are very important to the rights of the accused in the process of fair trial, needs to be done away with. It is against the international commitments, and we have to advocate that Indian state, honors its international commitments. PUCL is accordingly issuing a call that we do not stop here and we take forward our campaign against UAPA with greater vigor and ensure that Sharjeel and Umar are out soon, and all those who are under UAPA and under other draconian laws are also out soon and find our support and solidarity outside the jails that they are contained in. Thank you.
Thanks, Lara. I think now we'll just open the floor, and if anybody has any thoughts, questions, comments, messages of solidarity to share, the floor is now open. Maybe to take up from Lara's last point is perhaps we can have a bit of a discussion on the way forward. How do you take this forward from the current analysis? We have had an analysis of the limitations of the judgment of the Supreme Court. We also had an understanding that underlying the judgment is its fidelity to the UAPA. And the UAPA is, of course, not in conformity with the constitutional rights, both of speech, association, and assembly. And so the question really is, how can we take this forward in terms of a larger, broader, wider campaign against this particular law? Kavita, would you like to comment on this point?
Thank you, Arvind. And I just don't know how to remove the spotlight from you. So if Aishwarya is still there, and she can do that, somehow my computer is not. Okay, thank you. No, I think it was a very, very useful seminar, very, very useful presentations. And I think our own paper, which we prepared collectively, can perhaps add some of these suggestions or understandings that have come, because it's very important that the not just the PUCL members, but the human rights community have in their hands a comprehensive understanding actually of what is happening with the UAPA. So I feel that some little work that needs to be done, and I think this is for all our friends. Please read what we've written, but we would also send you an updated version later. It will be on our website, which is www.pucl.org. That is as far as just continuing understanding, continuing contact with us, taking off from this seminar. But coming to some of the other issues of how do we widen this discussion, I think that is the most important thing that we need to do. And it's so frightening what are shared by some of the lawyers, like what is going to happen? How can anybody exist in this country? And after all, it's the vulnerable, the marginalized who need to protest every day on the streets. And yes, there's complete targeted attack on Muslims, on Christians, but also on labor, on Adivasis. What have they done in the name of Naxalism? So I just feel that we really need to be in conversation with a very large number of human rights groups, and and actually once again uh, do something collectively, because I mean, these days in no city there is the right to protest and the right to association. So that is not just merely a civil, the way they've designed civilian spaces, it's very much part of crushing dissent. And when dissent becomes terror, actually the policy of the government of India, terror is their policy to terrorize us. We are not terrorizing them. There are no acts of terrorism of the sense that they're trying to implicate. It's they who are terrorizing us. And to act against this terror, we really have to be a much larger force. We have to be many, many more people. And so we've got to align with political parties. We've done it earlier. We brought all the political parties together at the time of Tada and Pota. PUCL was also instrumental in bringing together political parties. And so I think we need to, once again, we started that process with Bhima Koregaon. We need to once again work really religiously on it, and talk to all the political parties, because they are also the potential victims of all that we heard. Um, how can a opposition survive without these rights, without criticizing, without defaming the government? As Ms. Jaising said, is defaming a government an act of terrorism? How can it be? So we need to talk to all the political parties. We need to talk to other groups, and not just strictly the human rights groups. They can be anchoring this process, but we need to talk to groups across, because everybody's human rights have been infringed. So whether they're labor groups, whether they're environmental groups, I mean, at this point of time, I think in every state, the large number of protests that are happening related to the environmental questions. So I really think that it is the time to network. It is the time to hold hands. It is the time to build solidarity with each other, to stand up against, this whole idea of Indian state, their policy being terrorizing us, and to crush that spirit within us. Um, Lastly, I really want to say that we need to stand in solidarity. I think my connection perhaps is a little bad. We need to stand in solidarity with the families of the Delhi riot, those who have been still in jail. We need to stand in solidarity. 5 years, 6 years is just too long. And what can be that compassionate way of reaching out, that we're with you, the kind of isolation families go through when you have to fight this case. I mean, at the end of the day, you come out collectively in a protest, but when it happens against you, like when Delhi youngsters came together last month, to protest the pollution, the personal journeys of each one, became so difficult. So we need to get them out, and many of them are still in, many are out. So I really think that we have to have ways of reaching out to those who are in the Delhi riot case. 7 are still in, but also in the Bhima Koregaon, and the endless people who are, the Adivasis who are in jails, the minorities who are in the various jails, and the cases have not even come in for trial. So somewhere prison work is also very important for organizations of ours. And lastly, what are we going to do with this kind of judiciary? The independence of the judiciary is something that, again, this question we have to raise. The judiciary in this case behaved worse than the Indian state. They somewhere, sealed the cap on so many things against the people. It was such an anti-people court. How could they do it? So we've got to even be talking about it. The list is endless. I stop here. Times are very tough. So it is the time to hold hands and be in solidarity, taking small goals. Let's bring the 7 out. At the same time, let's network and attack the UAPA to its fullest. Thank you.
I think some of the suggestions we've got from the audience is that we have regular sessions on the UAPA, discussions on what is going on. So I think from the PUCL at least, we can say that we continue with this idea of PUCL dialogues and have weekly or bi-monthly dialogues on different issues. I think Sonam Wangchuk is another issue which we have to talk about, range of other issues which we really have to talk about. So perhaps with that commitment to continuing the discussion, and we hope that something will come out of these discussions, let's conclude this session with a thank you to all our speakers.
Just one, Arvind, just one moment. Some people have messaged me about how do they join the PUCL, how do they connect. So, friends, I'm putting, just write my number. I'm putting my number, in this list. If you people will contact us, we'll tell you the state PUCL organization which you can connect with, and that is also one way of taking forward these discussions. But we are on social media. I think we will start. We already have it. I think we have a separate tab on on our website on UAPA. I think so. We used to. Perhaps you need to do it and send you all updates about what we are doing or what is happening elsewhere. We are not the only ones who are talking about it. At the same time, the larger question of human rights is something that we all need to connect. Go ahead, Arvind.
No, I just wanted to conclude by saying thank you really to all our speakers, Ms. Jai Singh, Talab Mustafa, Nadeem Khan, and Mihir Desai, and Lara, of course, for really, I think as the comments really indicate, really uh, very, very productive and very, very informative discussion. And you also realize that the gap is in terms of what the media is portraying. So events such as this and sessions such as this are very important. Really, for people to really understand what actually is going on as far as these cases are concerned. For year after year, the Delhi riots cases, been the language of riot has been dinned in again and again. And it's very important that we keep deconstructing that. And for that effort, I think all our speakers did a really excellent job in providing more of a material information for us to think about the serious issues really before us. And I think we'll conclude on this note and say that this is not the last time we're doing this. We'll continue with this program of having regular PUCL dialogues on a range of human rights issues and try and build, as Kavita is indicating, wider and wider solidarities and work towards building a campaign on the repeal of the UAPA. Because the final target in this case has to be, as Lara is indicating, both UAPA and other draconian laws. They have to go, if we think seriously, or we take the question of the right to freedom, right to expression, association, and assembly seriously. But to protect those rights, these laws really have to go, and we have to really work at building a campaign on these issues, and that's the responsibility of a range of civil society groups in this country. Again, what we realize is the right to association is so central for every kind of work in this country. And again, you realize that if you see the recent very very marvelous essay by P. Sainath in the book edited by Justice Mulidhar, where he makes the point that it's absolutely fundamental that we have to look at the right to association for all, taking forward even socio-economic rights in this country. So I think this is a very core and central issue, this question of speech, association, and assembly. And we have to think of a way to build a campaign on these questions in the time going forward. Kavita has taken the numbers and contacts of people on the list. We'll get back to you with the next event in 2 weeks' time from now. Thank you again very much for joining me.
Arvind, I'm interrupting you. I just realized Suresh is also, he's the general secretary. He's the mover shaker of this organization. Suresh, please give the guest appearance if you're still around. Let people see you. And if you could just quickly tell us about the website, how to connect, and all that.
Yeah, I've thanks, Kavita. Hello, everybody. I've been hibernating for some time. I'm just suddenly popped up now. It's a wonderful discussion. A lot of issues have been raised. If you can send in the email ID, if you want to know more details about Section 43D5, the bail law in UAPA, there was an article we had written some time back. We can circulate to you, which gives you the history of how this draconian law has survived from the 1980s onwards. It is not a post 9/11 2001 war on terror law. This has a longer history. It goes back to the mid 1980s and the transistor bombs, of that period. That's one. Second thing, I think in the last part, Arvind had mentioned about freedom of assembly and freedom of association. Now, one part are these very big cases like the Bhima Koregaon case or the Delhi riots case. These are the ones which are occupying public attention, a lot of things. What is not given equal importance are the hundreds of people arrested under UAPA in Chhattisgarh, in Jharkhand, and various other countries. There is nobody to take up their cases. There is nobody who talks about them. There is nobody who will advocate for their release on bail. I think we all who are part of the human rights community owe a duty to them to be able to take up those issues also. Since a number of people have said you would like to know more about the Repeal UAPA campaign and you would like to be part of it, please do send to us by email your coordinates and we will get in touch with you. It's time that we need to oppose it. No, Ash, the UAPA law in 1967 was for the anti-Hindi agitation. They used it in 2004, in 2009, when they brought it back into the UAPA. There's a longer history to it. Yeah, 2004. I don't know to get into in a rushed manner.
Yeah.
There's a longer history to it. There's a history of how it went on changing. I would like to also end up positively by saying PUCL has played a leading role along with other human rights organizations in demanding repeal of TADA. You see, in the TADAs in the mid 80s and the early 90s, nobody thought that TADA could be repealed. Okay, and TADA was dropped. It was dropped by citizens coming together to fight. Same thing happened with POTA. Prevention of Terrorism Act, which replaced TADA. Again, agitations, protests, campaigns throughout India came out and we were able to pressurize the government in terms of dropping POTA. The same thing is happening now. So I think we will need to come together now. It was fantastic to hear Talib and others giving wonderful information. We need to put all of these things down and we need to continually take this message to the ordinary people. Trade unionists, slum dwellers, tribal community leaders, environment leaders, and all of them to say that this law can be used at any point in time. Basically, I would like to end up by saying the attempt of the government is to create a larger environment to make people believe that they don't have a right to question the government policies, that they have to necessarily accept what the government says without raising any questions as to the validity of a particular policy or a law. That is exactly what they are aiming at. This is also they are trying to see how they can inculcate this as a mindset amongst people. This is what through the PUCL dialogues we are hoping to break. And I'm glad that we almost had up to 100 people and many others watching the PUCL the YouTube channel. Yeah. Thanks everybody for coming and attending this. Thanks Kavita once again.
Thanks, Arvind, Lara, Talib, Ms. Jaising, Meher, Nadeem. Nadeem joined us from the train. So that was, yeah, that was very interesting that he was traveling back from Jaipur. So thank you, friends. You can remove the mute all.